is a free speech case, why don't you cite the First Amendment anywhere in your brief?
The brief and the brief does talk about the speech issues and the entire overbreadth, vagueness.
I'm looking at your table of contents, and I don't see a citation to the First Amendment to the United States Constitution. Am I missing something?
Welcome back to Bench Breakdown. This case starts off sounding simple, but it turns into a real debate almost immediately. An attorney walks in arguing this is about free speech, but the court isn't buying it right away. Within seconds, you can feel the pressure that starts to build as the judge starts to push back on what this case actually is about. Watch how quickly this shifts.
I'm not sure what's in the table. I came into this case. I did not personally write the briefs in this case. However, the case Caracarte from this court that this case stems from was a case where there was an overbreadth vagueness challenge. That's discussed at length in the briefs, and the
So here's what we said. Here's what we said in Caracarte. Quote: defendant's contention that the extortion statute is impermissibly vague by virtue of the term malicious is without merit. This court has repeatedly upheld the terms malice and malicious against a vagueness challenge. So it's a vagueness case, right?
The vagueness challenge is that's ultimately a First Amendment.
We can talk about the First Amendment, but it seems to me like what we as a court need to decide in this case is what maliciously and malice means in the context of a criminal statute, and whether malice here means malice in the legal sense, namely, as you and your opponent have briefed, malice in terms of intentional action in an illegal way, or malice in the sense of hatred. And it seems to me like before the notice you filed this morning, everything we had been reading was about that question. So I'm kind of interested in solving that one before we start talking about the First Amendment.
Well, I think they're related questions. I think if the court looks at the statutory interpretation question of what does maliciously mean in this statute, it's not defined in the statute. The court in Caracarte cited to this court's decision in Gaylord that found the same maliciously language that was not defined at that time in the child abuse statute to mean actual malice, to mean that you had to act with ill will. Then the legislature came in and said, no, that's not what we meant for child abuse. And they put in the statute for child abuse, maliciously means legal malice. They never did that in response to the Caracarte decision with extortion. The difference between child abuse and extortion is that child abuse does not, there's no constitutional amendment that's implicated in, you don't have a right to abuse your child. You do have a right to speak. That's why when the, statute is somewhat ambiguous, the First Amendment comes into play, because the court has to realize that the whole point of Caracarte was to protect the extortion statute from a First Amendment challenge, from the entire statute being invalidated because it was, overbroad and vague and ultimately violated people's First Amendment rights. So, without
I'm struggling to understand how the First Amendment issue relates to the question that's actually presented here about whether malice means actual malice or legal malice.
Well, the way that it relates is that actual malice protects the statute from being unconstitutional under the First Amendment, because it sets a high, the First Amendment has the whole true threats thing. You cannot, you can.
And sir, you argued this in your brief? You argued that the statute was unconstitutional in violation of the First Amendment?
No, I don't think the statute is unconstitutional in violation of the First Amendment.
If we interpret it the way you think we should interpret it. And this was argued in the brief.
No, I do not think that the statute is unconstitutional. I think that the statute has an actual malice component, and it has been long held that you cannot that you can criminalize speech that has an actual malice component to it. So I'm not.
I think what we're getting at
suggesting-
is that a lot of the cases that you do in fact cite and that the government has joined issue with are actually not free speech cases at all. They're due process cases. Vagueness is about when, because an act, a legislative act, speaks with unconstitutional breadth, it criminalizes conduct without notice to me.
Right.
That it is in fact criminal conduct as understood, because it is, violative of, the law and what has been enacted as a guide to, legitimate behavior. That's not a First Amendment question. That's a due process question. And I don't know how this whole discussion helps you win the case at all. What I was hoping we would engage in, and what I think we still have time to engage in, is a discussion about what to do with the question presented, whether there is a sufficient guide if we say that the statute criminalizes malice in the legal sense to people's behavior, so that prosecution can happen in a way consistent with due process. That's what I think the issue is in this case.
Okay. As to that issue, I think that with a statute not telling people what is the malice standard,
do you accept the premise that at common law extortion it just required what we're now calling legal malice?
I accept that. I think if you accept that premise, I'm sorry?
If you accept that premise, then I think the constitutional stuff goes out the window. And what you're left with is, what did the legislature do when they used the words that they used here? Either choice would be constitutionally permissible. Does the word that they used mean legal malice, or does it mean actual malice? I mean, I think you started off by saying this isn't just an ordinary statutory interpretation case. I think that your strongest case is to make it a statutory interpretation case. And so the question for you is, why, given the tools that we normally apply to understand words in statutes, why should we read the word maliciously here to mean actual malice rather than legal malice?
Okay, let me just say one
Counsel, I'm sorry. I'm going to jump on you a little bit here, too. Don't forget his question, but I have a follow-up question to that. Our common law understanding of malice has historically been legal malice. Would you agree with that?
No, I would not. What I was agreeing with in
so
Chief Justice...
you do not, hang on, you don't agree with that. Okay, so our common law understanding of malice, you say, if you don't agree that it was legal malice, you're saying that it's actual malice, historically.
Well, that issue was not briefed either. What I was talking about with the common law extortion...
Whether it's briefed or not, this is my question to you. Would you agree with that premise?
I have not researched the common law.
So take my word for it. So
malice,
historically, common law has treated malice as legal malice. And when we use words in a statute, it is presumed that we use the meaning that was given at the common law, unless the legislature specifically says we're going to adopt a different meaning. So if that is all true, why then should we interpret in this statutory context the word malice to be actual malice instead of legal malice?
Well, I think that the premises that Your Honor is coming from, if you look at the common sense definition of malice, what people understand malice to be, it is not just intentional, and when you're talking about giving notice to people of what is prohibited, what is not prohibited, when, someone's talking to another person on the street, when they say someone's acting maliciously, they don't mean, they did something intentional. They mean they did something evil. They did something
Well, let's talk about the dictionary interpretation of malice. If you look at Black's, dictionary, if you look at all the Merriam-Webster, in the legal context, what the first definitions that they lay out are always the legal definitions of malice. I think, if memory serves me correctly, there's only one legal dictionary that says, and there is also actual malice, but it doesn't lead off with that.
I mean, every dictionary that I've looked at, including Black's, has talks about both, definitions. So I'm not sure. I don't agree with the premise that every dictionary only talks about the legal malice, but
That's what this case really comes down to, how one word is interpreted and what that means moving forward. Curious, what do you think? Is this really about free speech or something else entirely? Let me know in the comments.